can't happen here.
Call to your oath level.
Tēnā koe, Mr Speaker, kia ora tātou katoa. Can I start by saying that the Māori Party will not be supporting this legislation? Mr Speaker, in the first 6 months as an MP in March of 2006, I supported the call for a broader debate on intelligence and security matters. From relatively fresh eyes as they were at the time, I shared the word on the street that the new anti-terrorism legislation being pushed through Parliament in way too much of a rush could see protesters or activists designated as terrorists. Even myself at the time, Mr Speaker. I was told a story from the very early days of the Māori Party in late 2004 when a Sunday newspaper had revealed that the Security Intelligence Service had launched a major covert operation investigating the Māori Party, our members, our leaders and our associates. Mr Speaker, Operation Leaf, the story revealed, had been a major SIS campaign targeting various Māori organisations over several years. The article disclosed that a former SIS agent allegedly said he'd quit the operation because of his disgust at a system that was spying on decent, law-abiding New Zealanders. Understandably, Mr Speaker, we were very, very angry about that. And yet the reaction from the Prime Minister at the time, Helen Clark, was that these allegations were simply, quote, a work of fiction and laughable. Mr Speaker, I take the time to go back just a little bit in time as a part of the history around surveillance and human rights in Aotearoa. There are other episodes, of course, the case of the Algerian refugee, Ahmed Zawi, a political prisoner imprisoned nearly half of it in solitary confinement and a maximum security without charge or trial. Or earlier still, sir, in 1996 when the SIS was caught trespassing in Aziz Chowdhury's house. These all form the history of the bill we're debating today. Mr Speaker, fundamentally, that is one of the greatest issues we have with the whole debate around the Government Communications Security Bureau and the current legislation. For the very nature of the work in question is such that we will never know whether Operation Leaf was indeed fictional or fact. Mr Speaker, the bill is being put forward to make amendments to the objective, the function, powers and limitation provisions supposedly, quote, to improve clarity about the legal parameters for the GCSB and to accommodate changes in the prevailing security environment, end of quote. Well, the New Zealand Law Society, as many have quoted already, were pretty upfront in what clarity actually means. In their submission, they said, Mr Speaker, the bill empowers the GCSB to spy on New Zealand citizens and residents and to provide intelligence product to other government agencies in respect of those persons in a way not previously contemplated and that is inconsistent with the rights to freedom of expression and freedom from unreasonable search and seizure. Mr Speaker, that's pretty hefty stuff. From people who are have high reputations, and it certainly alerts us to common concerns around the new powers to conduct surveillance. Mr Speaker, the underlying question must be, what does it mean for our people? We have to recognise the impact of context. Mr Speaker, the author Nicky Hager of The Hollow Men, of that fame, of that book, has noted that since the passing of Labour's Terrorism Suppression Act 2002, and this is a quote, people taking part in ordinary protests have found that they are being subjected to much heavier policing, end of quote. According to Mr Hager, police have routinely removed computers and exercised far tougher measures against people exercising a legitimate right to protest. You fast forward that to October 15, 2007, and the raft of search and surveillance methods used in the police terror raids and the subsequent human rights breaches recorded in Operation 8. Mr Speaker, let's make no mistake. Law enforcement needs must be adequately met, but at the same time in a way which is consistent with human rights values. And I tell you this, that the Māori Party will never stop stating the obvious, that we want the system to be held accountable for decisions that they took against so many innocent children who were taken from their homes, searched in the street in their nightwear, causing significant trauma in the process. We must have answers for the way in which the state embarked on virtual PlayStation assault against the innocent people of the sheltered valley of Ruatoki. That shameful period, Mr. Speaker, was followed by an equally disturbing raft of legislation, including the Video Camera Surveillance Bill forced through in 24 hours, the Search and Surveillance Act 2012, also known as the Guilty of Suspicion Act or the Creepy Peeping Act. And here we are again, Mr. Speaker, here we are again. Whether the government is red or blue is relevant. The secret surveillance of citizens appears to come with the territory of being the ruling power. So, sir, I come back to the question of why exactly is this new legislation required and what will it do? Now, Mr. Speaker, earlier this year the Māori Party wrote to the Prime Minister requesting a copy of the names of the 85 citizens who were the subject of potentially illegal surveillance by the GCSB that were revealed in the Kitteridge report. We suggested that to restore public confidence, the public disclosure of the names was required. The response we received from Mr. Ian Fletcher, Director of the GCSB, left us in no uncertain terms that names would not be released and that to do so might, quote, prejudice the maintenance of law. That is the catch-22 situation in which this bill is trapped, Mr. Speaker. In order to restore public faith, sir, public faith and confidence, we need to know more about the need for the proposed legislation. And yet, the activities of the Government Communications Security Bureau, by form and function, are not readily available for discussion. No explanation or justification for the conferral of the new powers are given. The explanatory note states that the Act, as it stands, quote, was conceived at a time when the nature, extent and potential impact of the cyber threat was dramatically different from the threat posed now, end of quote. But again, that explanation is only meaningful if one knows the nature and the type of the threat that is now faced. And that is the point also made by the Human Rights Commission. In a letter received today from the Chief Commissioner, David Rutherford, he recommended that New Zealanders need to have access to more knowledge about the potential threat, the potential nature of the threats that surveillance might be used to monitor. Mr. Speaker, the Māori Party believes a little knowledge is essential to ensure whānau are safe from being unlawfully scrutinised by the state and also safe from the potential threats that have supposedly preempted the need for this bill. That is the question John Adams, representing Huatau Marae, outlined in his submission when he said, robust checks and balances must be in place to ensure citizens seeking natural justice and due process are not labelled and treated as enemy of the state. He continued, history is littered with conscientious objectors to wacky government policy and those seeking natural justice and confidence in public process being targeted for surveillance and or marginalisation. Cherie Hereora echoed the same sort of concerns, defending the right of New Zealanders to privacy and to the freedom to go about their daily lives without being watched by a government agency as if they were criminals. Finally, Mr. Speaker, I want to leave the last word in this debate to the public health physician and senior lecturer at the Kupenga Hauora Māori at Auckland University, Dr. Rhys Jones. Dr. Jones of Ngāti Kahungunu expressed great concern about the objective in Section 6 of the bill around the economic well-being of New Zealand. His statement is powerful and warrants the attention of this House, so I quote directly from his submission. He says, if critics of government policies were deemed to be a threat to the economic security, the GCSB would have the power to spy on those individuals or organisations. This has serious implications for freedom of political discourse. Government surveillance or the provision for the government surveillance has a chilling effect on political expression and a detrimental effect on social relationships between citizens. It must be kept to an absolute minimum if we are to remain a free and democratic society. No justification has been provided for these powers, and therefore they should not be granted. Mr. Speaker, the government does not need any more power to survey New Zealanders. Freedom of association and freedom of speech are fundamental to any democratic society.
I understand the next call is a split call. I'll ring the bell at 4 minutes. The Honourable David Parker.
Thank you, Mr. Speaker. I was astounded